competition angle, there are two extremely important developments that are taking place. One is in the short term and one is in the long term. The short term development is, of course, the Competition Amendment Bill 2022. I'm not sure how many of you are aware. This is a conversation we've been having in the past 2018. The first committee was set up to reform the Competition Act in 2018. The committee submitted its report, it came out with a bill, then it was open to public consultation, then a new bill came, then it went to the Parliament Standing Committee on Finance, it gave its recommendations, and now an updated bill to a certain extent is supposed to come into being. So that is a conversation. Now the timeline for that is very immediate. The assessment is that because it was supposed to be introduced in the Parliament session, the budget session that is currently going on in the first half, which happened in February, but for whatever reason it was not introduced, and now a very strong expectation is that it will now be introduced next week when the second half of the budget session resumes. So once that comes into being, it's going to bring a lot of very, very important changes to the Indian competition law regime, which is going to affect the technology ecosystem especially. For example, there are conversations about deal value thresholds. For example, right now, the way Competition Act works is that if the merger control regime in Competition Act works is that if there's a transaction between two companies and they have their assets and turnover above a certain threshold, which is prescribed by law, they have to notify to CCI. And only when the CCI approves it can the transaction move forward. Now, the conversation was that, this is not something that will work for digital markets because a lot of companies do not have high assets and high turnover, but nonetheless can have an anti-competitive effect on the market if the transaction or the merger goes forward. So now the new criteria, which is in addition to the other criteria, is a deal value threshold. That if a value of a deal is above 2,000 crores and it has something to do, it has a local nexus, it has a nexus with Indian business operations, it has to be notified to CCI. So similarly, there are a lot of very important changes to the Competition Act which are being considered and will come out. And then as we look at what's next for 2023, that's the first thing that we should be looking forward to as early as next week or next week. So if that doesn't happen for whatever reason, because you never know with the government, then I think it has to be tabled by the monsoon session. But there's a good chance it will be tabled in this session itself. There's no official word, but that's the assessment of most people in the policy space right now. On competition only, a very, very important piece of legislation that is now being considered is a Digital Competition Act. Now, a Digital Competition Act is a new framework altogether. Now, the genesis, and this is a development that I'm working very closely on with a lot of people, and the genesis of this bill is that there is countries across the world have a specific piece of law or a specific piece of legislation which is ex ante in nature rather than ex post facto. The difference between the two is ex post facto currently, which is what we have in place. It's very, very nuanced difference, but in one line, the difference is that currently how competition investigations or how competition assessment takes place is that, let's say, I as a company, violate Section 3 or Section 4 of the Act. Now, either the CCI will take suo motu cognizance, or someone will go to the CCI and file a complaint. The CCI will then look at the conduct a detailed investigation, then come to a finding, let's say, whatever time it takes. The average time, we did an analysis of the amount of time it takes between a prima facie order of the CCI and a final order is almost 3 years. So that's just a bit of trivia there, that it takes a long time for that assessment to take place. But anyway, that's how it works right now. Now, what an ex ante framework like the Digital Competition Act that we're now talking about does is that the government or the law will give you a set of 10 do's and don'ts. It will say that these are the 10 activities, you can do this, you cannot do this, and that's it. If you do this, there will be a penalty. You have a right to be heard, but then beyond that, there's no detailed investigation that is going to take place the way it does right now. So it says ex ante. Ex ante means before the fact has occurred or before the conduct has taken place, and just saying that this conduct cannot be done and it's been prohibited. So that is something that is not India's. India is not the first country to experiment with these kind of legislation. This is something that has been. We have the Digital Markets Act in Europe, in EU. which is the landmark legislation of this kind of law across the world. It has the kind of, let's say, effect on international legislations, the way the GDPR had for privacy. Once the GDPR came, everyone wanted to do something similar on data privacy. Same thing with witnessing with the DMA. Once the DMA came into being, a lot of jurisdictions tried to do something similar. The UK came out with a law. The US is looking at some laws. South Korea, Turkey. I recently heard even Taiwan to a certain extent. Australia, Japan, all these countries are now looking at some sort of ex ante frameworks to, in the domain of competition law. So the interesting part about the Digital Competition Act is that right now the way Competition Act works is that it applies on everyone. It applies on every markets, be it your technology markets, be it your steel market, etc., 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 agnostic, right? The Digital Competition Act will only and only apply on technology markets, right? So the idea here is that, and this is coming from the DMA, which is largely the inspiration for most laws, is that there are certain set of 10 or 11 markets that they've identified. Let's say the instant messaging market, where you have platforms like WhatsApp and Signal, etc. You have your online intermediation markets, which is your platforms, including your food delivery platforms, your tab aggregators, your goods marketplaces, your online travel agencies. Similarly, there are 10 sets of practices 10 markets that they've identified. Now, on these 10 markets, they will see who are the gatekeepers. Now, gatekeepers is a term which was coined by the Digital Markets Act, and in India, we're calling it systemically important digital intermediaries, CDs for short, right? So then they will identify these CDs. Now, these CDs are ones who are the most important and the most dominant players in these specific markets that I just told you about, right? For example, in the instant messaging market, you can expect WhatsApp to be one of them, right? So there are certain criteria which the DMA has. You have to have a market capitalization above ABC, turnover itna hona chahiye, monthly usage itna hona chahiye, all of that. Point being that they will identify certain players, and this law will only apply on those players. Let's say a set of 10, 15, 20 laws, 10, 15, 20 players, however many as they may be. It will only apply on the most important players in these 10, 11 markets, right? That's the idea, and that's a huge change from the way we do things right now. We do have the concept of applying certain laws on only some players. The data privacy law and the IT rules, they do talk about similar concepts like that significant social media intermediaries, the large players who have an extra set of regulations applicable to them. So similarly, we're now going to have something similar in the Competition Act. So in the competition domain, how this has developed is that there was a parliamentary standing committee on finance which came out with a report in December 2022, which recommended a similar framework. It listed out 10 or 11 practices. It said that these practices need to stop. Example being deep discounting, predatory pricing, search bias in platforms where certain platforms place certain search results on top, not on the basis of any objective criteria, but just because maybe those results are linked to the platform themselves or whatever reason there may be. Anti-steering provisions on app stores, things like that. They've listed out 10, 11 practices, and they say that it recommends that you need a Digital Competition Act for systemically important digital intermediaries, and now a new law needs to be formulated on that. Now, acting on that report, the Ministry of Corporate Affairs in February constituted a new committee. It's called the Committee on Digital Competition Laws, the CDLC. It has 16 to 17 members, a lot of lawyers from top law firms, a lot of one or two industry representatives, and then 10, 11 government representatives. They've nominated one representative from multiple committees, from multiple ministries, someone from MeitY, someone from Niti Aayog, someone from Ministry of Commerce, etc., etc. Now, they've been tasked to the task of the ministry, or the mandate of this committee is to come out with a report in 3 months, and which discusses that, okay, does India need a DCA, a Digital Competition Act? If we do, what's the feasibility? What are the international frameworks on it? How is the rest of the world looking at this? And also come out with a draft digital competition bill. So they've been mandated to come out with that bill in 3 months. So, I mean, it's very likely that the timeline will extend, because 3 months is a very short time. But going by what the official statements state, state is that in 3 months they have to come out with that. So if that happens in 3 months, then of course the next few months go into public consultations, etc., etc. And this is again then this is the starting of this law. So if it happens, it should come out as an enforced law in December, in maybe budget session next year or monsoon session next year, but not this year, because it does need a lot of work that needs to be done before it's tabled in the parliament. So that's what's happening. It's a very important development for anyone who's especially interested in competition law.